Good morning. Hello, everybody. Hello. Good to see you. Good morning. Yes. Hello. Happy Friday. Yes. Well, hello. Hello, everybody. Hello from Chicago. Love that. Good to see you. Yes. Good morning. Welcome. 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 Yay. Friday morning flex. Woohoo. 4 p.m. in the UK. Woo. From New York. Oh, hello, welcome, welcome. Also, oh, from the UK again. Okay, we love that. Yes, good morning, everybody. Good morning. Good to see you. Good to see you. Oh no, did something happen with Sue's? Oh no, we can't have that. That's not okay. Oh, Minnesota. Oh my gosh. Yes, thank you so much. Oh my gosh, good morning. Good morning. Hello, Jen. Hello. From Michigan. They still call it the mitt, don't they? The mitten. Hello, Steffi. Hi, welcome everybody. Oh, from Texas. Hello and welcome. Yes, no powdered wigs. Absolutely. That's so funny. Oh, oh, good morning. Yes. Oh, St. Louis. Oh, you got muted last night. Oh my gosh. Oh, Suze, it does. It gets crazy. Or the glove. Okay, okay. I wasn't quite sure, but oh, Suze, I'm glad you're back. Oh my goodness. Oh, hello, everybody. Hello. Yes, good to see you all. So, we've got kind of a bonus morning live today. We've got an order that came down out of the New York case, and this happened just yesterday. And so I wanted to take you through. Oh, you got muted too. Sorry. Yeah, things get a little bit crazy when we get a lot of people on. So we've got, yes, yes. So I will put a sticky on for sure. But we've got an order that came out yesterday regarding the assets. You may have heard something about it. Judge Engron had said, hey, don't be moving your stuff around. So I thought I would take you through that order this morning. It'll be kind of a shorter live just to say hello. Upload these to YouTube. Yes, I do. Actually, last night's live is processing right now. So I'm hoping to have that up in the next couple of hours. Hopefully, we'll see. It takes a little time, but should be ready. Good morning, Hawk. Good to see you. Yes, so I do have kind of a quick personal chef to really. Oh, whoa, Steffi. Oh no, national secrets. Oh dear. Oh my goodness. Yeah, that whole situation. That's a lot. It's a lot. So, yes, yes. And I have no doubt that the submarine situation is not the only it's not the only situation. Yikes. So, yeah, so I will be going through Judge Ingron's order and then kind of just doing a little overview of the case first, go into this order, and then kind of explaining that a little bit. So, kind of a morning bonus live today on the New York civil case. But I will be back again at my usual time, 6 o'clock Central Time tonight. And I've got two orders of business for tonight. I will be going through the Giuliani civil suit that's been filed against President Biden. So I will be going through this tonight at 6 o'clock Central. And then I also have the motion to dismiss. So I will do both of those tonight at 6 o'clock Central. But this morning, I wanted to give the most up-to-date order that came out of New York. Okay, so here we go. Let me just give you a bit of an overview on the New York case, just to remind everybody. In New York, we just had a motion for summary judgment granted, right? So, as to cause one, explaining, yes, there was fraud and you need to dissolve your businesses. Now, we are set for trial for causes 2 through 7, which are what's left of the case. I've gone through so far a couple of things. First, we've talked about the notice regarding the jury, right? Trial without a jury here. There's some question about whether or not a jury is actually allowable under this particular section of the New York Code. So there's this whole thing here regarding that. So we don't have a jury, it's a bench trial. Also reminding everybody you can go online. I'm working to put together a post to explain how to do that. But until then, let me just use my words. But you go online to the New York State Unified Court System and you put in Donald Trump as the defendant. Then you will click on the people of the state of New York versus Trump. So you'll click on this tab. Once that window comes up in the bottom right-hand corner, it goes into e-file documents. Once you click on that, this page will come up. Okay, so you will be able to find all of the exhibits, all of the court filings for the entire case, all available on online, and you just need to go to the New York State Unified Court System, find the defendant, add the defendant's name in, pull this case, here's the index number, and then pull up the e-file documents. All right, so we've got several documents that have been set out. One thing that has been very helpful is document number 3, which is a chart of deceptive strategies. I went through this a little bit last night. So that particular chart explains all of these different deceptive strategies that were used, and then we've got all of the different colors that coordinate to all of the different properties and all of the different years. So this chart is incredibly helpful. Again, it's document number 3 if you were to go and look those up online if you're interested in looking at the evidence yourself. All right, so there you go. Right, so then the next, it does look like a subway map. And then the last thing I'll remind everybody about is we do have witness lists, one for the state and one for the government. So here is the state's set of witnesses that they plan to call. Here, their witnesses are set out, and then we have witnesses that may be called only if needed. So as you probably know, we've already had Mr. Bender has testified, and I believe Mr. Connie is still continuing to testify. So this is the state's list. Their primary case in chief is what we would call their presentation. They have their rebuttal witnesses as well. Going onto this page, and then we've got defense witnesses here. One thing that you'll note about defense witnesses is that we have a bunch of expert witnesses. So they have a ton of different experts they plan on calling in to kind of explain their accounting strategies. I'm not sure that the judge will actually permit all these experts. The judge has already ruled on the fraud, so now it's a matter of intent. So if these experts can kind of help assist showing the intent level, then that may be allowable, but we'll see. So it looks like we've got a total of 12 experts, just confirming. We were talking about that last night. So that's the update. And then we did have a supplemental order from the judge yesterday explaining, some parameters that he's put on the case. So I will take you through that language of this order. Now, this order is only 3 pages, so I probably will not do a sticky note because the name of the case is right here and the judge's name is right here, but I will explain. Night Train, do you know the judge? Oh, Night Train's gone. Sorry, everybody. My allergies. Daisy, welcome. Always good to see you, Daisy. All right, so let me take a seat here and I will walk you through this order. It's not very long, but I'll explain what the different pieces mean. So there you go. Wow, we got some trolls in here today, don't we, everybody? Goodness. Goodness. Good morning. Good morning, Jay. Good morning. How do you find this information online? So sure, let me show you one more time here while we kind of weed out the trolls here. So what you'll do is you'll go online and you'll look for the New York State Unified Court System. All right. So this is the website, and then when you go on, you have a chance to put in plaintiff or defendant. You'll put in defendant. You'll put in Donald Trump. Now the next screen that comes up, you'll have to click people of the state of New York. Once you click on that, then it'll give you an option to click on e-file documents. Then you click on that, and then there you go. The entire docket, all the orders, all the evidence will come up for you. So I will try to, I'm continuing to try to put a video together to show you the exact steps, but you know, I'm a lawyer, not really that technologically advanced, but I'm working on it. Absolutely, absolutely, everybody. So no worries. Let me then take you through this order. We do have that motion for summary judgment in which the judge has ordered the dissolution of, oh, hey, look, I just found the tolling agreement, everybody. Oh my goodness. Everyone who's been joining me has been asking about this tolling agreement, and I could not find it yesterday. It was attached to the order. Wow. Okay. So I do have the tolling agreement. Oh my gosh. Should I go through the tolling agreement first, everybody? I know, right? I just found it. Look at that. I told you I've got paperwork. I have so much paperwork. Oh, yes. Okay, go through it. Okay, we'll go through it. We'll start. We'll start with the, that's so funny. I'm just cracking up. All right. So let's talk about the tolling agreement first, and then we'll get into the special order. Oh my goodness. All right, so hold on just one moment. Let me grab my highlighter. Just one moment. Okay, thank you for your patience. I am not a morning person, so I'm doing my best. So bear with me here. But yes, let's go ahead, hydrate. I got the coffee. Oh my goodness. All right, let me take you through the tolling agreement here. That's the first thing we'll go through. Okay, here we go. So let me just highlight this so everybody knows what we're talking about. This is the infamous tolling agreement that was signed. So the tolling agreement regarding potential violations of the New York False Claims Act and Executive Law Section 6312. All right, so this is the actual contract that was signed between the government and Trump. So this agreement, called the tolling agreement here, is entered into by the Attorney General of the state of New York with the Trump Organization, together called the parties. So let's make sure we highlight each party here. We have the parties. Now, I always like to make sure I pull out all of the characters, the cast of characters, so we're familiar. Can you explain what exactly a tolling agreement is and how it's relevant? I will. Let me take you through the language first, and then I will do a summary of what it means. All right, so I think it's easier once you actually see what the language says to kind of explain it. So here are the two parties involved, all right? We have the Attorney General and the Trump Organization. But yes, I will do a summary. Let me just make a note so that I remember, so I don't forget. I'm a bit absent-minded, especially in the morning. but I'll do my best. All right. Yes, good morning. Good morning. All right, here we go. So this is the exact language. Now let's just double check on the date that this was signed, just so everyone is familiar. Oh, I don't have the date of the signature. Hold on, let me double check here. This one doesn't have the date, so let me pull up the exact date here so everyone knows. All right, so the tolling agreement was signed. It was dated August 27th of 2021. All right, so let me just put that information here. August 27th of 21. So both sides signed the contract. All right, so let me get into the language here. The Attorney General is conducting an investigation of conduct of the Trump Organization and related parties, including their agents and employees, for potential statutory and common law violations in connections with the statements regarding Donald J. Trump's financial condition, representations regarding the value of assets, and potential underpayment of federal, state, and local taxes. So let's just pull out here what the purpose of their original investigation is. So we've got assets and taxes. Such potential violations include, but are not limited to, violations of the New York False Claim Act and Executive Law Section 6312. The state's potential civil claims arising out of this investigation will be referred to collectively as potential civil claims. All right, so we've got our first opening paragraph for the contract. Now, one thing I want to do before I get too far here is bump down and take a look at who they've listed as the Trump Organization. So here's our footnote. Let's bump down here. As noted in December 27th of 2019, subpoena issued in this investigation of the Trump Organization. So the Trump Organization, as used herein, includes the Trump Organization Incorporated, DJT Holdings, LLC, DJT Holdings managing member, and any predecessors, successors, present or former parents, subsidiaries, and affiliates, whether direct or indirect, all directors, officers, partners, employees, agents, contractors, consultants, representatives, and attorneys of the foregoing, and any other persons associated with or acting on behalf of the foregoing, or acting on behalf of any predecessors, successors, or affiliates of the foregoing. All right, so this is the Trump Organization here. When they say the Trump Organization, they're referring to this paragraph. All right. So, all right, here we go. Next, we've got the parties believe it is in their mutual benefit and interest to enter into this agreement in order to permit the AG to pursue its investigation and to determine whether to commence any legal action or proceeding concerning potential civil claims. Accordingly, the parties agreed to the following. So this is the contract that both sides have agreed to, all right? It's not one side or the other. Both sides have agreed to all of these conditions. First of all, we got to remember that. So, in any action commenced by the AG asserting any potential civil claim, the applicable limitations period shall be told as to such potential claim for the period A, beginning on November 5th of 2020, and B, continuing to and including October 31st of 2021, the tolling period. So let's make a note of that. We have a tolling period now that's been set out here, the tolling period. So the beginning in November 5th of 2020 and continuing to October 31st of 2021. All right. And again, both sides agreed to these terms. All right. Now, again, we know if you miss the statute of limitations, you can't bring a suit. So if you've got a contract between two parties agreeing to pause the statute of limitations, you can do that. That's absolutely legitimate. In the sole discretion, the AG shall have the right to extend the end of this tolling period from October 31st of 2021 to April 30th of 2022. Again, those dates are very important. So there can be an extension, and you'll find out later there was actually an extension. So to April of 2022, provided, however, the AG exercises such right by, on, or before October 1st of 2021 by delivering notice to counsel for Trump Organization. So here's the tolling period, and then it did get extended, and I'll go into that in a minute. In the event that the AG asserts any potential civil claim, the Trump Organization agrees not to assert or rely on the tolling period as a legal, equitable, or other defense to such potential civil claims. All right, so let's note that here. They're saying if the AG comes back and says that we've got civil claims, the Trump Organization is agreeing to not say the statute of limitations has run. This is what the tolling agreement is. This is the most important part. All right. They agree that the statute of limitations is not going to be a barrier to bringing the suit. So Trump is saying it's fine. The statute of limitations is not going to be applicable. We are agreeing to that. Both sides are agreeing to that. All right. This tolling agreement does not constitute an admission or acknowledgement that any particular statute of limitations is applicable to any particular potential civil claim. Nothing in this tolling agreement shall be construed as precluding the Trump Organization from asserting a defense, response, or claim. Let me get my sticky note out here, everybody, so that I can label this. Yep, no legal advice, legal education only, which is completely allowable by law and ethics. All right, so let me just get my sticky note going here, and then I'll continue on. All right. Here we go. We've got the tolling agreement. So it does not prevent the Trump Organization from asserting a defense, response, or claim of untimeliness as to any potential civil claim brought by the AG, provided that the Trump Organization shall not, in asserting such defense, response, or claim, rely on the passage of time comprising the tolling period. So if they had statute of limitations questions, it's fine, but they cannot ask any questions that are protected by the tolling period included in this agreement. All right? So you remember the dates that they included in the period of time. Those dates are now covered by this contract. Next, let's just highlight this. In the event a notice or other... Oops, let's bump back up. I got too excited about the tolling period. Further, the execution of this agreement shall not prejudice any party's position with respect to any other defense, response, or claim. So this is kind of a disclaimer here. In the event a notice or other papers shall be necessary, such service shall be made by first-class mail and emailed to the undersigned. This agreement may not be extended, modified, or altered except in writing signed by the parties. This agreement may be executed in counterparts. The Trump Organization agrees that it is entering into this agreement knowingly and voluntarily, so these are essential elements to any contract, and in express reliance on the advice of counsel. This agreement shall be governed by the law of the state of New York without regard to any conflict of law's principles. So next we've got the agreement shall not be modified except by writing signed by the parties hereto. This is mostly just pretty normal contractual language. We would include this in almost any contract. Let's see. This agreement and any execution or modification thereof may be signed in counterparts, all of which together constitute the agreement, and photocopies, electronic or facsimile copies may be used as originals. Number 12. Nothing herein is intended to modify, diminish, or supersede any tolling period affected by Executive Order 202.8 issued by Governor Andrew Cuomo on March 20th of 2020 and its subsequent extensions, including the extension in Executive Order 202.73. The parties shall retain any arguments regarding any such tolling period that existed as of November 5th of 2020. So these executive orders had to do with different timing requirements regarding New York law during COVID. Okay, so just to make sure, that everybody understands that. That's what we're talking about. Steffi, did you get muted? How did you get muted, Steffi? What's happening? Oh my goodness. All right. Number 13. The Attorney General reserves its right to, in the future, seek a judicial equitable toll of the statute of limitations retroactively to whatever date it chooses. Number 14. If an issue arises subsequent to the execution of this agreement that the OAG concludes constitutes an additional ground for a judicial or equitable toll, meaning anytime we see this word toll, it's going to mean stop. All right, it's stopping the clock on the statute of limitations. So the AG agrees to advise the Trump Organization of that issue at least 7 days prior to the filing of any court papers and to work in good faith with the Trump Organization to resolve the issue without the necessity of judicial intervention. This paragraph is not binding, however, in the context of a pleading alleging the potential civil claim or an action or other proceeding in which the potential civil claim has been alleged. Number 15, the Trump Organization reserves any right to oppose such judicial or equitable tolling on the merits, but agree they will not assert laches, estoppel, waiver, or any other equitable defenses that the AG sat on its rights by not filing any motion, proceeding, or action, which, of course, they did, actually. They did file those things. And that's part of why there were sanctions, because it went against the specific language in their contract. Between today's date and the date of filing, each of the undersigned representatives of the parties certifies that he or she is fully authorized to enter into this tolling agreement and to execute and bind such party to this document. Number 17, the terms, meaning, and legal effect on this tolling agreement shall be interpreted under the laws of New York State. All right, so there you have it. That's the tolling agreement. All right, so what they have here, again, the entire point of this is that the parties believe it's mutually beneficial to enter into the agreement in order to permit the AG to pursue its investigation and determine whether to bring a legal action. So everything that had been done, because this was ongoing litigation at the time. So at the time that this agreement was signed, there was a case that the AG's office was pursuing. So this is from the motion for summary judgment order. All right. So we've got this situation out of the Court of Appeals. First Department modified the court's order to the extent of declaring the continuing wrong doctrine does not delay or extend the statute of limitations, finding that claims are timely against the defendant, subject to the tolling agreement if they accrued after July 13th of 2014, and timely against the defendants not subject to the tolling agreement if they accrued after February 6th of 2016, and 3, dismissing the complaint as against defendant Ivanka Trump on statute of limitations grounds, finding that she was not an employee of the Trump Organization at the time at which the parties entered into the tolling agreement coming out of this particular case. All right, so both parties agreed to this tolling agreement, which paused the statute of limitations. Now, the judge goes on to explain part of the reasons why there were sanctions is because they kept coming back filing motions regarding all of the things they agreed to in the tolling agreement. So that was what became one of their biggest issues, all right, was they kept saying the statute of limitations has run. Meanwhile, in the agreement, they had already said they're not supposed to pull that defense. And they had said too, they're not supposed to bring in other types of things, and they continued to do that. So that's part of the reason why there were sanctions, was because they signed a contract and went against that contract by making the filings that they did. Okay? Why would they agree to a tolling agreement? I think what had happened in this case, let me pull the exact language here. Let's see. Oh, hold on here. Just one moment. So, okay, thank you for your patience. I found it here. All right, so Alan Garten, the Trump Organization's chief legal officer, originally entered into the tolling agreement on behalf of the Trump Organization on August 27th of 2021. The agreement was extended one time by an amendment dated May 3rd of 2022. It tolls the statute of limitations for this period of November through May, and the agreement contains a footnote about the entities here. So the tolling agreement at issue here binds all the directors. It's undisputed that at the time the tolling agreement was executed, the individual defendants were all included in that. But the reason why it was done is set out over into the next piece of it. So hold on, let me flip the page. 13, 14. Oops. 13, 14, 15. So part of this, so he goes into what's in the binding agreement, this estoppel issue and so on. But what had happened was then New York had agreed to stop the suit that they had already filed. So there was a suit. This is the lawsuit that they had filed investigating these fraud claims. They agreed in 2021 to halt their investigation because there was a lot going on in 2021, and it would have benefited, and it did benefit Trump, for them to pause their investigation. So they paused the case, and they agreed to pause the case instead of going forward, because this case could have been brought to court back in 2021, is what I'm saying. They were going to bring this same suit, just with less numbers, back in 2021, but they agreed to pause their lawsuit against Trump because Trump agreed to pause the statute of limitations. The statute of limitations is 6 years. 2011 is the first set of numbers they used. So 2017 would have started the statute of limitations to have been over. So in order for them to not run into any statute of limitations issues, Trump agreed to waive those statute of limitations questions in exchange for the Attorney General's office to stop litigation. All right? So that was why they entered into the agreement. The Trump Organization had the Attorney General's office stop litigation. They paused their litigation for 2 years. And then in exchange, they agreed to these terms, that they wouldn't fight on estoppel issues, that they wouldn't argue the statute of limitations for this agreed upon period. The reason they were sanctioned is because all of these conditions in this contract, they violated because of the motions that they filed. They filed motions repeatedly violating these different pieces of the tolling agreement. All right? Everyone following me on that? Okay, that's okay. 2 underscores. Yeah, that's okay. As long as there isn't anybody that is trying to make any profit off of it at this point, I'll take a look and see. Yep. Okay. Excellent. All right. So everyone understands now the importance. This tolling agreement's the key to this whole case. Yep. Yep. Oh, yeah, I'm not worried. I'm not worried. They tried to confuse the process. They did, and they filed motions that went against what they were contractually obligated to do. So, again, the estoppel issue they brought up, the period of time, the statute limit period that they agreed to, they brought it all up. And that's why the judge sanctioned them, because he said this has been resolved over and over and over again. You keep filing motions going against what you agreed to in a signed contract. Who violated it? Trump, and Trump's team violated it. Why the attorneys would agree to this? Well, I think for the AG's office, it gave them more time to put their case together because they were really under a time limit because of the statute of limitations. So by pausing this litigation, it gave them more time to put their case together. Now, for Trump, it gave him this grace period where he didn't have to be brought into court constantly at that particular time. So he was able to do other things at that particular time. Again, we've got a lot of stuff going on at the time. So it helped for him. He didn't have to go into court. It helped for the state because they had more time to prepare their case. So both parties benefited from the agreement. So when he brought this case, he wasn't running for office. No, he wasn't. When this case was first brought, he was still saying that the election had been bad. So there was all of the media regarding that. Now, this was signed August 27th of 2021, right? So we're actually still kind of in COVID at this time. There is a lot going on. We've got challenges to the election going on. There's lots of things going on at the time. So it was beneficial for him, for the Attorney General, to stop rather than take the suit all the way to its end. And then the Attorney General was like, sure, fine. And then they used that time period to put the rest of their case together, as well as include any numbers for the next few months, which they did. Yeah, that's exactly why he ran again. Could very well be. Yep. Needed time to address his other. Well, I'm not exactly sure about that, but it's definitely was a huge benefit to him to not be going through this exact situation back in August of 2021. That's what happened. So instead of having a civil trial right now, like we're having, we would have had this back in August of 2021. He would have been taken into court by the AG, but they agreed to pause it so they could get more time to put their case together. Hydrate. Yes. He knew the pause was up. I think that's a great way of putting it. Yes, he did. And then they came in and pled in their motions, and they said none of this stuff. They said all of the things they agreed they would not do, they filed, and that's why they were sanctioned. Did his lawyer change the tolling agreement? No, they both mutually agreed to a later date. So, as one of the different pieces in this explains, it was possible to change the period of time so long as it was done by October 1st. And that's what happened. So that was included in the order. Oh, it's right here. It's number 2, actually. It says here they could extend it, and they mutually agreed to extend it actually until May. So that agreement was done by both parties. I'm not sure when Ms. James came into office. That's a good question. Who prepared this document? I don't know who actually wrote it. I don't have that. Does he have the same legal team? I don't know about that either. That's a good question. This was signed officially by, let me make sure here. Whoops. It was signed by his chief financial officer, so it wasn't signed by an attorney at the time, but it was signed by his financial officer on behalf of everybody. So let me just pull that name. I've got to show you the exact place. Yep. Just a minute here. Here we go. Scienter, non-party, parent conflict, here, fragments. Let me just see here. Here we go. Sorry about that. Took me a minute. Alan Garten of the Trump Organization. So the chief actually was. Okay, was. I thought he said the chief executive officer, but it wasn't. It was the chief legal officer. Originally entered into the tolling agreement on behalf of the organization. So this is the person. The chief legal officer entered into the agreement. Yep. No, it's here. It just takes me a minute to get it. It's all here. Oh. Yeah, you don't have to take my word for any of this stuff. It's all documented. All of it. So, all right. So there you have it with this tolling agreement. Now you can see how important this is. And you can pull this up online. Also, again, you would go to the New York State Unified Court System. This is the website. You put in Donald Trump as a defendant. Pick this case here. This is the people of the state of New York versus Trump. And then once you click on that, it'll give you an option to click on e-file documents. And then you can pull up this entire list. This particular tolling agreement is a document 412. But there's plenty of examples of it. So the draft tolling agreements have been sealed, so they are not allowed to be viewed by the public. But this is 412. Yep. All right. Yeah, I don't know anything about any corruption. I just know about the law, is all. Can you show the first page again? The first page of the evidence here. Right. Here you go. Yep. If you screenshot this is the website you want here, the New York State Unified Court System. That's really the key. Oh, yep, you got it. Yep. And then you just need to make sure you put in Trump as the defendant and then click on the people of the state of New York case and then e-documents, and you'll be able to pull it up. Which would put his appeal in jeopardy since he has no basis on the appeal for proving otherwise. Exactly, Trish. Exactly. And I think that's why this judge is like, we need to keep this moving. And the other reason why he was able to do this motion for summary judgment, a lot of people are saying, well, how could he decide this whole case? Well, the whole case was already decided because all of the arguments that they're making was exactly what they put into this contract because the AG's office knew that these were the arguments they would make. So that's why they signed the contract. And so now they're kind of going back on a signed legitimate legal contract. So is Ivanka going to testify? Maybe. She's on the list. She's on the list for the state. All right. So here's the next thing then. This isn't very long. It's only 2 pages, but the judge just entered this order on yesterday. So, my mods are amazing. I'm so thankful for my moderators. I'm truly thankful. So here's the order he entered. He needed to kind of clear some things up with the defendant, and I think he did a pretty good job. So let me take you through his order. I'm not going to use a sticky note just because it's only 2 pages, so you can kind of see again what this is. So on October 26th of 2023, the court issued a decision and order, the September 26th order, and that is this order here, okay? Denying defendant's motion for summary judgment and granting in part plaintiff's motion for summary judgment. The September 26th order, among other things, ordered that any certificates filed under and by virtue of the Business Law Code Section 130 by any of the entity defendants or by any other entity controlled or beneficially owned by Donald J. Trump, Trump Jr., Eric Trump, Weisselberg, and Jeffrey McConney are canceled. The September 26th order also directed the parties within 10 days to provide the court with the names of potential independent receivers to manage the dissolution of canceled LLCs. And so it is hereby ordered. So here is the substance of his order, which is interesting. Do you think that he went through attorneys, his newest ones just weren't aware of the tolling? I think they knew, and the judge set it out as well in the sanctions order that they knew and had been told repeatedly. So I think the fact that the district court as well as the appellate court told them over and over and over again, even all of the attorneys that are sitting there right now, yeah, they all knew about it. They all knew about it. All right, so it's hereby ordered. The parties shall have until October 26th to provide the court. Maybe I will do a sticky note, everybody. Actually, once I see this now, it looks like it's not quite clear enough. So this is the New York civil case order that just came out yesterday, October 5th. So here we go. I'll just add this on for anyone who's new and joining us. Move it to the right. Okay, here we go. How's that? Is that better? Should be better. Yes. Oh, my moderators. So thankful, so thankful. All right, excellent. So they shall have until October 26th to provide the court with names of potential receivers. And it's further ordered that within 7 days of the date of this order, which was yesterday, defendant shall provide the independent monitor, the Honorable Barbara Jones, with a list of all entity defendants and all other entities controlled or beneficially owned by Donald J. Trump, Trump Jr., Eric Trump, Weisselberg, and McConney that have existing certificates filed pursuant to this section. So again, this is a section of New York law, just explaining what a business entity is. You have to register with this particular law in order to get a certificate, in order to incorporate and do business in New York. And it's further ordered that for each of the Section 130 entities, defendants shall inform the monitor whether and to what extent any third party has an ownership, partnership, or membership interest in such entity. And it is further ordered that the plaintiff shall assist the monitor by confirming through access to the Department of State records the information provided by defendants regarding the Section 130 entities. So all of the businesses licensed in New York, all of that information, who owns it, who has any interest in it, all of that information needs to be given over to the monitor. It is further ordered that for each of the Section 130 entities, defendant shall provide the monitor with advance notice of. So this is how the behavior, or this is what he is not allowed to violate. So if he violates any of these, it would be a violation of a court order. So number one, any application for a new business certificate, including but not limited to doing business as or assumed name certificates in any jurisdiction. All right. Whoa. So the judge is saying if he's going to try to refile new certifications in any jurisdiction, that needs to be given to the monitor. Yeah, it's a lot. That's a lot. That's a big deal. That's a pretty big deal. Number two, the creation of new entity to hold or acquire the assets of a Section 130 entity. Oh, thank you. All right. So if they create any new entities in order to kind of set the assets of these businesses in them, all of that has to be disclosed to the monitor. Number three, any anticipated transfer of assets or liabilities to any other entity. So any movement with these 130 businesses has to be disclosed as well. Any anticipated distribution from a Section 130 entity. So any distributions, any assignment of rights from a Section 130 entity. So any kind of movement, getting different people involved or moving assets, all of that has to be disclosed. Number six, any disclosures to third parties regarding the transfer or cancellation of the business certificates. So this is pretty significant as well. So any disclosures to third parties, including but not limited to correspondence to the Section 130 entities, lenders, banks, financial companies, leasing agents, insurance companies, buyers, equity partners, co-owners, or taxing authorities. Whoa, So anything regarding a transfer or canceling of these certificates, all of the disclosures that they have to make to everybody, all of that information has to be shown again to the monitor. So he can't hide anything. No, nothing can be hidden. He cannot transfer anything. Nope. He's saying you are not allowed to transfer. You are not allowed to create new entities. You're not allowed to even talk to other banks or any of the people involved in your companies without telling the monitor. What if he doesn't comply? Well, it's a court order. So anytime that you are in a violation of a court order, any of the sanctions that the judge could do because of that would be applicable here. So it's like any order. If you were to think, if we put this into, I hate to use family law as an example, but I think that's the easiest one to think of. If you had a court order visitation, all right? So visitation is to be every first weekend of the month, and you did not comply with that order, what would the judge do then? What would be the repercussions for not complying with that judicial order? It's the same here. So if a court has ordered you to do something, to make a payment at a certain time, to do a certain action, to enter into a program at a certain time, and you don't do that, anything that the court could do because of that noncompliance is what they could do in this case. I'm not sure. I think the judge is enforcing the gag order. And I say that because we had a gag order, right? And then we had comments made. And then we had this order come out. See what I'm saying, everybody? See what I'm saying? Are you following me on that one? No, it's not, Reed. Nope. That's not how the First Amendment works. But yeah, okay, yeah. Are you following me? Are you seeing? Are you seeing what happened here? Right, exactly. So the judge has this level of accountability here. The judge can continue to go forward. So we have this order. We will see if more orders will come. Possibly. Now, the judge didn't say that, but this is a pretty strict order. So you have to wonder, why was this put into place? Yep, judicial discretion. Exactly. So number 7, any modifications to existing contracts or obligations with any counterparty. And here's the last piece, any notice by a counterparty declaring an event of default resulting from the September 26 order, including the cancellation of the certificates of the appointment of a receiver. Okay. So, and this was dated actually on that day, on the 4th. Is this a civil case? Yes, it is. Yep. So the judge, and I think, the judge has such broad discretion and how they can get their court in order. And a lot of things that they can do can just make someone, very uncomfortable. And it can be a very distressing situation. And this judge, I have no doubt, even by example of this order here, is going forward and saying, this is my courtroom. What if the wife files for divorce? Can she stop it from being dissolved? No. Can't threaten a judge and the staff without repercussions. Exactly. Nobody can. I mean, it's like no one can do that. If they leak anything, the case will be thrown out. Yeah, no, I don't know about that. We've got years of this kind of an investigation going on. Yeah, leak what? Exactly. I mean, what's there to leak? Oh my goodness. This right here is all public information. There's no leaking of anything. You can look at every single document here. Seems excessive. Well, we'll see. I mean, the judge does what the judge feels they need to do. And in this particular situation, if you look through his order on that motion for summary judgment, he was so frustrated. The Court of Appeals was frustrated. And they're just, there's certain things you can push back on, but one thing is when you are in a business court, right? And you have a judge who's been on the bench 20 years and has been doing this like for 20 years, he's not going to take any bologna sandwiches from anybody. So it doesn't matter who you are. He's going to bring you back into order. That's his job. Yes, it will stand up to appeal. Absolutely. Absolutely. I have no doubt. I have no doubt. And again, quite a bit of what was in his order, this is the order here on his motion for summary judgment, was in reference to the Court of Appeals. The very court that they are appealing to was in here repeatedly. And he cited them repeatedly and said the Court of Appeals is frustrated and cited the Court of Appeals decisions where they said, knock it off. And so I don't think so. Thanks for all the work. Oh, of course. I'm happy to help if it helps people to understand this a little bit better. Could this be the judge finding what he cares about? I believe so, Suze. I think that's exactly it. I think that is exactly it. I think probably one of the things that will drive this particular defendant crazy is being told what he can and cannot do. I think that is probably one of his currency pieces. So for this judge to come in and explain, you're not allowed to do this, you're not allowed to do that, in this order, that's exactly what is going to, kind of affect this defendant. And this judge is a seasoned judge. He knows how to find that currency. Never be able to look at bologna sandwiches. Oh, no! Yes. Trying to keep it family friendly, He's not used to rules or consequences. He's really not. And the judge was like, look, we have rules. You're not following the rules. And he's like, well, we didn't have to follow the rules. And the judge is like, you do have to follow the rules. So, again, you've got this seasoned judge on the bench. You're not going to be able to win that. No one's going to be able to win it. Some people are saying, oh, he's a Democrat or he's, whatever. He's tainted. Who cares? This judge has been on the bench 20 years. There is nothing you can do or say that this judge will accept that he doesn't want to accept. So he's old school. He's going to do what he needs to do to keep his court in order. I have no doubt. I have no doubt. He makes the argument. Can only drive the car. I wasn't the one who robbed the bank. I agree. But, he's the one that picked the bank. There's a lot of elements to it for sure. Yes, I think it's good for everyone to kind of have a basic understanding of what's actually factual in the legal case, in this case in New York, and what is not, because there's a lot of information. Trial. Another big one was about the statute of limitations question, which again was all agreed to in a contract by both parties. So I think it's important to, be able to find a place where you can actually find the documents and look at them yourself. He can do anything he needs to do to keep his court in order, and that's true for any judge. That's law school 101. That's just what you learn on the first day of law school. The judge is in charge of their courtroom, and they can do what they need to do to keep their courtroom in order. That's just how the system works. Appreciate you doing this. Yes. Oh, of course. I'm glad it's helpful. His supporters will not even read these orders and motions. I know. It's a lot. I think it goes way beyond the order. Well, maybe, but all I have is the order. And all the judge can do is enforce the order. They can be held in contempt. Yeah, exactly. Again, the judge's only power is truly within that courtroom and how he's running his show. And that's true for all of the judges in all of these cases. That's where their authority begins and ends. And so once you enter that courtroom, you are under the purview of that judge. And, that's part of their job description. It's part of what the requirements are for being a judge, is keeping your courtroom in order. Will he serve jail time for violating the orders? I don't think so. I'm not exactly sure what kind of contempt situations, what can be done in New York, because that's not my jurisdiction. But I don't think we're going to switch into a loss of freedom here in New York for this, for contempt. The more I looked into it, I mean, in my jurisdiction, it's possible. Even in a civil case, if you upset a judge enough, the judge can, put you in the clink. But that's my jurisdiction, very different from New York. But here, I think because it's a civil case, no, I don't think jail time's on the table. But I think there are a lot of things this judge could do. A lot of things. What's this case about? Yeah, it's about filling out false information on financial documents. Yep. So it's a pretty, I'm in the central time zone. I don't give my exact location out, but yeah, I'm in the central time zone. Yeah, I think a lot of people feel like he's being targeted, but I mean, there's also, I guess in the legal field, if you break the law or violate the law, I mean, it will eventually, it will find you, and you will be held accountable usually. So I think it just is everything is falling down all at the same time, I think is what's so interesting about this. But this New York case, this was the first. This was way before the New York criminal case. This was way before DC, Florida, Georgia. This was the case that started everything, all right, when it came to accountability. And this started all the way back in 2017 with Cohen testifying. So, this has been going on for quite a long time. Wants them to be held to the same standards and expectations. Right. I think so. Prosecutors are waiting to see how this plays out. I agree, that's a piece, except for in Georgia. Georgia's its own animal. That judge isn't playing around. That judge is like, this is my docket. We're going to get in and get out and get her done. Yeah, I mean, I know. If people would take the time and just look at just a few of these exhibits, I mean, it's not that complicated. I'm certainly not a business law attorney. It's not my favorite area of the law. It's one of my least favorite areas of the law. But even for me, it's like, wow, this isn't too complicated. It's pretty simple. Yep. What did he do in Georgia? Yeah, the judge there is just like, look, you guys wanted speedy. We're going to give you speedy. So stop, messing around. We got stuff to do. Any average Joe would have been arrested. I agree, Kitty. I think that there would have been tax implications. There would have been criminal implications that would have gone down the road. So I think this is definitely special treatment. And this judge, though, is not having it. This particular judge, Judge Engoron, and the Court of Appeals, too. Both of them. And if you go through the judge's order here, he explains that as well, that the Court of Appeals is, getting tired of it, too. Like, you've been dinking around in the system here, dude. We've got rules. You need to follow the rules, and get this off my docket. Yeah, I agree. Yeah, and we've got some really good judges, Some judges are complete rubbish, but some, we've got some great judges too. So, about Hunter and Joe. Yeah, I think there are definitely some interesting issues going on in there. Is he getting the Al Sharpton deal? Ooh, I don't know about that. I don't really pay attention. Work for Morgan Stanley, you can't be $2 off. Yeah, Suze, it's true. I mean, that's a true story. Can you imagine any of us, if we go and apply, let's just use the example of a credit card. You fill out that document and they say, how much do you make a year? And you're like, let's say you make $100,000 a year. Just, let's just say you do, hypothetically. And instead of $100,000, you put, I make $500,000 a year. That's essentially what happened here. So he filled out the paperwork, inflating it by hundreds of percentage points. And then because of that, they give you the credit card with a limit that's reflective of your $500,000 a year salary. So, I mean, if any of us did that, we'd be in huge trouble. So it's the same kind of situation here. And he's saying no one got hurt. I'm like, okay, well, the credit card company didn't get hurt either. So I paid my balance every single month. I don't see what the problem is. If they didn't get hurt, why was me lying about $500,000 a year on my financial statement that I swore was truthful? Why is that a problem? Yeah, right. If you paid the credit card, right. So even if I pay the credit card every month and it doesn't have a balance, then can I lie about my salary and say I make $500,000 a year when in fact I make only 100,000? Is that okay? Is it okay to lie on a financial document like that? Just because, I'll pay it back, who's it hurting? Well, it's fraud. That's like what fraud actually is. Right, right. Well, that's the thing about fraud. Fraud means lie. Fraud means untruth. Untruth means lie. So lie is the word. Lie is actually the word. Why is the New York Supreme Court involved in an ongoing case? Well, the New York Supreme Court is actually their trial court, their district court. It's just named the Supreme Court because it's so old school. Should be taxed on the valuation. Yeah, I think there's definitely some tax questions coming into play. Is it illegal to put household income to that answer and still be wrong? Yeah, I think you can be a little bit wrong. I just don't think you can be wrong by, $250 million. I think that's really the difference. I don't think you can say on your tax form, my house is, 500 square feet, when in reality, your house is actually 25,000 square feet, right? So I think those kinds of numbers, those huge inflations and deflations of numbers, just the quantity size is pretty significant. Yeah, we would be in jail. We would be. Yeah, we would be in jail. Yep, I agree. Yeah, 400%. Yeah, exactly. Right, the credit card. Well, come on, you know what I mean. We all might fudge a little bit, and that's what the whole defense's argument is. Like, oh, we fudge a little bit. Listen. Okay, listen. If you're fudging a little bit, like you do on how much you weigh for your driver's license, okay, that's one thing. But if you're fudging by hundreds of millions of dollars, literally hundreds of millions of dollars, now we've got some questions, okay? All right, that's really what this is about. This isn't about just rounding up or kind of being a little bit generous with your numbers, just a little bit. Maybe everybody does that. No, we're talking about $250 million inflation on a $50 million property. Yeah. Yeah, no one got hurt. Right. Oh my gosh. Yes, no, don't freak out, everybody. I doubt you are adding $250 million to your assets. Okay. Oh my gosh. Oh, thank you for that. But yeah. Well, I'm not biased when it comes to fraud. Let me go grab one slide here. I've got one more visual aid I can show you that I think will help a little bit. So just one moment. Okay, so here we go. And again, this case in New York, it really is a documents case. So these are the rest of the counts left in New York to be taken care of. And if you look at this, you'll see he's not being charged with causing harm. He's not being charged for a victim. He's being charged with falsifying records. The only thing that you need is a record and the fact that he falsified it. That's it. Fraud, false statement. So it's not, the count isn't, he hurt the banks or he didn't pay money back. That's not the cause. The cause is that he falsified a business record. So that's really the key. Yes, right. So let's take a look. Yeah, let's take a look here. Here's my chart. Here's an amazing chart that's been put together. So in the blue, let me just move it over a little bit here. Here we go. Right, so in the blue is the actual value, right? And in the red is what he claimed was the value. So again, we're not just fudging here by a little bit, or even by just a few million, or even by 40 million. We're fudging by hundreds of millions of dollars. All right, so that level of fudging is not okay. And in fact, in 2014, his assets were inflated by $2.2 billion. $2.2 billion more than what his assets actually were. Okay, I mean, that's a lot. That's a lot of fudge. It is a lot of fudge. I mean, come on, right? I mean, so yeah, I mean, we're not talking like, hey, he was off by a little bit or he overestimated. Like, everybody overestimates. I get it. And that's his argument. But we don't overestimate by $2.2 billion. I mean, come on, right? It just seems so, it seems so simple to me. I don't understand why people are like, no, it's so wrong. I'm like, dude, he wrote $2.2 billion more than he actually had. Right. It's not about the banks. It's about the fact that he falsified the business record. That's what the law is, and that's what he's been charged with here. That's what the claim is about. You cannot falsify your business records. Now, you say everybody falsifies. Well, maybe a little bit. But, if you falsify a record by $2.2 billion, somebody's going to catch you someday. And that day for Mr. Trump is today. So that's what's going on in this case. I have no doubt other people are fudging. But again, if you're fudging by $2.2 billion, that's a lot. It's just a lot. I mean, again, I would be more understanding if it was like, oh, he overestimated a little bit. By billions of dollars, it's like, what are you talking about? And pushed off today. Yes, exactly. And this case was originally brought years ago, but they paused it because they both signed a contract, the tolling agreement here. They signed the contract and agreed to pause the litigation. But yeah, I mean, there's just nothing you can do. And, these are just factual numbers, just facts. He's going to call in different witnesses to say that these numbers in blue are wrong. That's what he's doing. That's all he has. And the judge is not really having it because here they're trying to say we didn't have any intent to defraud. But if you just look at the sheer number difference, how can this not be intentional when you're inflating something by $2.2 billion? What other reason would you have for inflating that if not to try to get a benefit for having numbers those huge? Right, and then he lowered them when he got his taxes. Right, I mean, and that's a whole nother issue. I mean, that's not, what is being pled out in this particular case. I mean, that's a whole nother case. But it goes again to show what the intent was, right? I mean, why would you bump up your assets by $2.2 billion? What would the intent be for that? Right? Yep. Tax fraud might be next. It could be. It's possible. Yes. So tolling means stopping the statute of limitations. Yep. Yep. To get on the Forbes list. Well, that's certainly part of it, according to Michael Cohen's testimony. Yep. Yep. Wouldn't, if lowered the value for taxes, wouldn't that show intent? Yes, it would. It does show intent, and it's, it is mentioned in the state's case, but that intent element is just extra. It's like extra frosting on the cake. It's not even frosting on the cake because the cake's already frosted. It's extra frosting on the cake. The tax implications. This case was over when they said that his penthouse was 30,000 square feet, when it's actually 10,000 square feet. That's when this case ended. That's the moment this case was over. That was it. Yep. This is the frosting decoration. Yes. Well, yeah. Yeah, I mean, and who knows what, the motivation was for the banks. Who knows? But does tax fraud have a statute of limitations? Yes, it does. I'm not sure what it is, but it does have a statute of limitations. That's what's so unique about this case too, though, is because of this tolling agreement. Again, they're able to go past the 6-year statute of limitations. I'm sorry, but what evidence is so clear you don't even need to be a judge to comprehend? Well, right? I mean, right? This isn't even my area, man. I'm a criminal attorney, constitutional, but even I can understand this. Yeah. And again, those numbers are different. The numbers are different. Mona, why did it go on for so long? So, great question. We had testimony coming in from Michael Cohen. That's what gave the alert to the AG's office. They started investigating. When they started investigating and continued going forward, they paused their investigation because of the tolling agreement. They paused it as a benefit to Trump, and also because the numbers were so extensive, they needed more time to put their case together, is what I'm assuming. So it went on this long because nobody caught it. Nobody was paying attention. And I think that really shows like the perfect example of if you put yourself out there at a certain level, people are going to believe you. And when you are a billionaire and you say, I'm a billionaire, and people aren't double checking on things for one reason or another, who's going to catch you? But here we had an AG paying attention to what one of Trump's lawyers was saying, and she caught it. And she caught it in time to bring the case. What was the actual amount that he claimed for taxes for each of those inflations? That I do not know. That is not included in this case because it is not a tax case. But those numbers have been crunched and are mentioned in passing in the motion for summary judgment order. So the judge does bring that up. Yeah. The Apprentice sold lies. Yeah, I mean, right. And, maybe not everything was. I'm not saying everything was, but what I am saying, what I can confirm, according to the evidence, are his financial statements were lies. Okay? That's what I can confirm. We just stick to the record, stick to the facts. Financial statements were lies. That's what I do know. And you're not supposed to lie at that level. That's just not allowable. Because if you do, you're going to get charged with falsifying records, false financial statements, literally false financial statements, literally, that's the code section, and insurance fraud. I mean, that's what happens. Probably has always lied. Probably, it could very well be. Yeah, I mean, it's just facts. It's just dollars and cents. I mean, that's what the numbers are. And all of the facts are available to the public. You can look at all of the documents, all of the exhibits, everything here. It is all available online, all of it. Emails, phone calls, all of the records showing the inflation of numbers, showing the reduction of numbers. You know, it's all available. It's all there. It's all signed. Can a civil case lead to a criminal case? Absolutely. Both ways. Criminal case can lead to civil and civil can lead to criminal, but it's all about the statute of limitations. I do not know when the statutes would run in New York for this kind of a situation. Because again, the key to this case is this tolling agreement that paused the statute of limitations, or else this case would have been in trial 2 years ago. Yeah, he's spazzing out every day. Well, I mean, it's a lot. It's a lot. Yeah, I mean, it just is what it is. I mean, you just can't argue. We're not even talking about, like, you know, do we believe the sources? Like, it is literally just paperwork. You use accounting principles everybody uses, and according to those accounting principles, he, inflated the numbers. Can you do a video telling people where to research this? Yes, I'm working on that. I am putting one together. Right now I'm just mostly talking through it. I'm trying to figure out how to best put one together. But yeah, Jimmy, nope. Oh, sorry, Jimmy. No. Facts of this case aren't up for debate. Right. Well, I mean, right. I mean, they're really not. The judge is like, dude, even the judge is like, we're done. We are done. We're done with the facts. I've already ruled on the facts. So, but they want their day in court. And, you know, I get it. I totally understand that. They want their day in court, and they will have their day in court. But, you know, again, what will happen in the end? And even with the Court of Appeals, they've been on this case for years, and they know what's going on. So, you know, if he's putting everything into the appeals basket, it's not going to be very helpful for him, because again, that's another reason why sanctions were given, was because they filed all these motions that were against the tolling agreement everybody signed on to, and then they were told to stop it, and they kept doing it, and then they kept appealing on all of those motions, and then getting sent back down, and then appealing again over and over and over again until the appellate court was like, you know, knock it off. Yep. I mean, yeah, it's a pretty it's really, when you just look at it legally, I mean, it's a pretty easy case. This would be the judge calls it a documents case, and I think that's absolutely accurate. It's just, was the document falsified? If so, then we're done. There's not really a lot more to it than that. Yeah, there's just not much more. He can continue to appeal, but, I think, that it's a delaying tactic, and that's fine. He can do that. That's within his rights. Bring up the Area 51 box. Oh, that's funny. Who did he defraud? Oh my gosh. Pat, no! What's this chart? Okay, so this chart is a visualization of the numbers that were involved. Okay, so we have each year. In blue, we have his actual assets according to industry and economic accounting principles, right? So according to accounting, true factual principles, the blue are his assets. The red is what he wrote on his financial statements. When does it get to the point of too many appeals? There aren't too many appeals. You can appeal everything, but then the courts, the appellate court, can just say no and send it back down. It'll take less and less time for the appellate court to review each appeal the more frequently you appeal. But yeah, you can appeal. He can appeal everything. He can do interlocutory appeal. So if any evidence is being ruled on by this judge and the judge is like, no, I'm not going to allow that evidence, even though it's a bench trial, they can appeal that. All of it can be appealed. Yep, it's a lot. It's a lot. But it's also what happens when attorneys get out of control, man. I mean, that's one of the big pieces here. There are 5 attorneys getting sanctioned, $7,500 each. I mean, that's almost $40,000 worth of fines for these attorneys for continuing to file all these motions. And they will probably continue to do that. How long will it take for the appeals? I'm not sure, but the Court of Appeals in this particular situation, they know what's going on. So, but they've got hundreds of cases that they're dealing with too. I mean, more than that, probably thousands of cases in New York. So they're like, dude, we don't have time for this. Take a look at it and then send it back down is what most likely would be allowed. Your appeals are really unlimited unless it's in bad faith. Now, the courts could view things as in bad faith, as they've done here, but I mean, you can appeal any of the judge's decisions. If there is a court that is higher than the court you're in, you can always appeal. Yeah, I think this chart's really helpful to really put it together. Again, we're not talking we just fudged a little bit here. We're talking, $812 million. That's, quite a bit of fudge. That's a lot of fudge. Does he still have to pay the fines while appealing? Good question. And I'm not sure exactly how they would work that. Right now, he's already put in a notice of appeal on his motion on the summary judgment order, right? So this order that was issued by the judge, there is a notice of appeal now that's on record. And so he's asking to pause the trial while this appeal is going forward. Now, if the Court of Appeals grants that, which I doubt they will, then it could be put on pause. But, I'm just not sure. It's a kind of a case-by-case situation. And the reason I bring that up is because the fines can't be assessed until the end of this case. So until this case is over, we don't know what the fines are going to be. And this case is expected to go until December. Try doing this on your own finances and ask the judge, right? Your Honor, who's the victim? Judges love that. They do. No, they don't. They do not love that. No. That's going to get you into some pretty significant trouble. Easier to ask who wasn't defrauded? Well, yeah. I mean, kind of. I mean, it's just like, it's a lot. It's a lot. And again, one of the best ways to visualize this was this chart that was put together by the AG's office, where they went through each of the strategies that was deceptive, so fraudulent, and then they lettered it and color-coded it, and then went through all of his properties from 2011 to 2021 and applied each of those deceptive strategies to each piece of property. So, I mean, if you just break it down, if you just crunch numbers, there's really not much left to the case. Yes, so this chart here and this chart, you go online, right, to the New York State Unified Court System. Go to the website, then you would put in, you can search by party, and you put in Trump as the defendant. Then there's a whole list, and then you go to the people of the state of New York, click on that, and then you look at the e-filed documents, and that will pull it up. This particular chart right here that I've been going into is the third document that's been filed. So the chart of strategies. So if you're looking for this one explaining all of his properties, that's number 3 on the list of the different documents that are involved. Yes, I'm still putting together a video on it. I may just need to do like a really rudimentary video, just filming my computer maybe. I know I'm just not that advanced, everybody. I apologize for that, but I'll do my best. I'll do my best. I'll put something together to kind of explain it. Oh, you're doing it. Oh, VC. Oh, you're my angel. I'm so thankful for you, VC. Yes. No, I got you, hon. I got you. Yes, I will. I'll definitely put it together. Fraud requires a victim. No, fraud requires a statute making fraud illegal. That's what fraud requires. That's it. Can use Loom. Okay, I've got to do more research. Yeah, I've got to really get into that. I sound like Kamala. I've heard that, although I don't think I haven't really paid attention to Kamala. I'm sorry, but I don't think I've ever heard her talk, actually. Yeah, the chart's pretty amazing. So you can pull this up, and also this is part of the state's opening arguments. So if you're interested in this chart, along with You do? VC, I haven't been registering with mine. Oh, you have to register with the site to create the work. Sure. Okay, I got you now. So on the very last page, it's one of the last filings here. We have the New York Attorney General's opening statements, right? So document 1550. So that's where this particular chart and her entire opening statement are located. Right. There's tons. I mean, if you think, I did a post on vice crimes, right? Where a lot of people claim that prostitution is a victimless crime, or gambling is a victimless crime, or drugs and alcohol, because you're choosing to do what you're choosing to do. And they're saying that's a victimless crime. It's like, no, those are vice crimes. And, fraud, again, is another one of those crimes. Or speeding, nothing happened. So why can't I speed if I want to speed? Well, because there's a law that says what the speed limit is. It's the same thing. The bank's lending him money based off of... Right. Yeah, DUI, exactly. Yeah, right. So, I mean, there's always some harm that's done, but the important thing is that there's a law. And if you violate the law, then you can be charged. So, the certified signature, that's another piece of it too, exactly. Because you're certifying that what you're saying is true. And that's not true. Not true information. Right, not paying taxes is a crime against everyone. So true. Yeah, exactly. And it's been going on for years. And again, I mean, we're off by billions of dollars here. We're not just off by a little bit. This is, I mean, come on, this is a lot. Keyword crime. Yeah. You mean we don't get to individually decide what laws we agree? Well, yeah, I know, crazy, right? We elect people, right? So this is all because people voted. This has to do with voting. So you have to vote. You don't like this? Go and vote. And ask them to change your law. That's how it works. It's not bad math. Yeah, I mean, there's really not much math involved, and thank goodness, because that is not my strong suit. Worst tax evasion of all time. I know. I've been doing some research on Al Capone to kind of compare, but there's no comparison. There's nothing to compare this to. $2.2 billion. I mean, oh my gosh, I can't find anything even remotely similar to this. Yeah, true. If you looked at every business, it would be a lot. It would be a lot. Yeah, it's a lot. So, yeah, it's a lot. Well, on that point, everybody, I'm noting the time here. So my special morning live, I'll need to kind of bring us to a close here. But I will be back again tonight at my usual scheduled time, 6 o'clock Central Time. And tonight... on my docket will be the Giuliani case. All right, so we've got Giuliani versus Biden, which is, I don't know if we can even use the word case. I don't know if it's really a case or not. There's a lot of problems with it. I will be going through this, and I'll also be going through the motion to dismiss for the DC case. I will be going through that tonight as well. So the motion to dismiss is thin. It's, I would consider it to be a frivolous motion, honestly, but it's criminal court. The standards are a little bit different. So we've got that. This is, again, the trial schedule for October with what's going on. We've got more discovery due in Georgia. We've got pretrial motions on Monday in the DC case, along with the demurs in the Georgia case. We've got the Florida SIPA hearings and SIPA challenges due. New York criminal case, motion to dismiss is due on the 10th. I'll be going through that criminal case on the 10th. Garcia hearing, so conflict of interest in Florida hearing is coming up. The gag order hearing on the DC case is on the 16th. More hearings again in Florida regarding the SIPA questions. Then we've got the jury starting to come in for the Cheesebro and Powell case in Georgia. So that will be going on here. And then that takes us to the 23rd where we start the trial in Georgia. So it's going to be busy. It's going to be very busy, but it should be fun. I mean, fun for us, for learning. It's fun to learn. It's not a fun situation, but it's fun for learning. Yes, cheese and crackers. Yeah, coming up, coming up. So thank you again, everybody, for joining me. I'll go ahead and sign off now, but always good to see you all. I will be back again tonight, 6 o'clock Central Time. Oh, thank you, Hawk. That's so sweet of you. Thank you, thank you. So we will go through those two different documents tonight at 6 o'clock. And again, thank you all so much for joining me. I will try to get that video posted on where you can find the documents as soon as I can. So have a great rest of your day and happy Friday, everyone. I'll go ahead and sign off now. So take care.